Part 16, Roman Commonwealth by Spiers. Copyright 2018. Section VII. The Parole. 119. Prisoners of war may be released from captivity by exchange and, under certain circumstances, also by parole. 120. The term parole designates the pledge of individual good faith and honour to do, or to omit doing, certain acts after he who gives his parole shall have been dismissed, wholly or partially, from the power of the captor. 121. The pledge of the parolee is always an individual, but not a private act. 122. The parolee applies chiefly to prisoners of war whom the captor allows to return to their country, or to live in greater freedom within the captor's country or territory on conditions stated in the parole. 123. Release of prisoners of war by exchange is the general rule. Release by parole is the exception. 124. Breaking the parole is punished with death when the person breaking the parole is captured again. Accurate lists, therefore, of the paroled persons must be kept by the belligerents. 125. When paroles are given and received, there must be an exchange of two written documents, in which the name and rank of the paroled individuals are accurately and truthfully stated. 126. Commissioned officers only are allowed to give their parole, and they can give it only with the permission of their superior, as long as the superior in rank is within reach. 127. No non-commissioned officer or private can give his parole except through an officer. Individual paroles not given through an officer are not only void, but subject to individuals giving them to the punishment of death as deserters. The only admissible exception is where individuals properly separated from their commands have suffered long confinement without the possibility of being paroled through an officer. 128. No paroling on the battlefield, no paroling of entire bodies of troops after a battle, and no dismissal of large numbers of prisoners, with a general declaration that they are paroled, is permitted, or of any value. 129. In capitulations for the surrender of strong places or fortified camps, the commanding officer, in cases of urgent necessity, may agree that the troops under his command shall not fight again during the war unless exchanged. 130. The usual pledge given in the parole is not to serve during the existing war unless exchanged. This pledge refers only to the active service in the field against the paroling belligerent, or his allies actively engaged in the same war. These cases of breaking the parole are patent acts, and can be visited with the punishment of death. But the pledge does not refer to internal service, such as recruiting or drilling for recruits, fortifying places not besieged, quelling civil commotions, fighting against belligerents unconnected with the paroling belligerents, or to civil or diplomatic service for which the paroled officer may be employed. 131. If the government does not approve of the parole, the paroled officer must return into captivity, and should the enemy refuse to receive him, he is free of his parole. 132. A belligerent government may declare, by a general order, whether it will allow paroling and on what conditions it will allow it. Such order is communicated to the enemy. 133. No prisoner of war can be forced by the hostile government to parole himself, and no government is obliged to parole prisoners of war or to parole all captured officers if it paroles any. As the pledging of the parole is an individual act, so is paroling, on the other hand, an act of choice on the part of the belligerent. 134. The commander of an occupying army may require the civil officers of the enemy and of its citizens any pledge he may consider necessary for the safety or security of his army, and upon their failure to give it he may arrest, confine, or detain them. Section VIII, Armistice, Capitulation. 135. An armistice is the cessation of active hostilities for a period agreed between belligerents. It must be agreed upon in writing and duly ratified by the highest authorities of the contending parties. 136. If an armistice be declared without conditions, it extends no further than to require a total cessation of hostilities along the front of both belligerents. If conditions be agreed upon, they should be clearly expressed and must be rigidly adhered to by both parties. If either party violates any express condition, the armistice may be declared null and void by the other. 137. An armistice may be general and valid for all points and lines of the belligerents, or special, that is, referring to certain troops or certain localities only. An armistice may be concluded for a definite time, or for an indefinite time, during which either belligerent may resume hostilities on giving the notice agreed upon to each other. 138. The motives which induce the one or the other belligerent to conclude an armistice, whether it be expected to be preliminary to a treaty of peace, or to prepare during the armistice for a more vigorous prosecution of the war, does in no way affect the character of the armistice itself. 139. An armistice is binding upon the belligerents from the day of the agreed commencement, but the officers of the armies are responsible from the day only when they receive official information of its existence. 140. Commanding officers have the right to conclude armistice binding on the district over which their command extends, but such armistice is subject to the ratification of the superior authority, and ceases as soon as it is made known to the enemy that the armistice is not ratified, even if a certain time for the elapsing between giving of the notice of cessation and the resumption of hostilities should have been stipulated for. 141. If it is incumbent upon the contracting parties of the armistice to stipulate what intercourse of person or traffic between the inhabitants of the territories occupied by the hostile armies shall be allowed, if any. If nothing is stipulated, the intercourse remains suspended as during actual hostilities. 142. An armistice is not a partial or a temporary peace. It is only the suspension of military operations to the extent agreed upon by the parties. 143. When an armistice is concluded between the fortified place and the army besieging it, it is agreed by all authorities on this subject that the besieger must cease all extension, perfection, or advance of his attacking works as much as from attacks by the main force. But as there is a difference of opinion among martial jurists whether the besieged have the right to repair breaches or to erect new works of defence within the place during an armistice, this point should be determined by the express agreement between the parties. 144. As soon as the capitulation is signed, the capitulator has no right to demolish, destroy, or injure the works, arms, stores, or ammunition in his possession during the time which elapses between the signing and the execution of the capitulation, unless otherwise stipulated in the same. 145. When an armistice is clearly broken by one of the parties, the other party is released from all obligations to observe it. 146. Prisoners taken in the act of breaking an armistice must be treated as prisoners of war, the officer alone being responsible who gives the order for such a violation of the armistice. The highest authority of the belligerent aggrieved may demand redress for the infraction of an armistice. 147. The belligerents sometimes conclude an armistice, while their plenipotentiaries are met to discuss the conditions of a treaty of peace, but plenipotentiaries may meet without a preliminary armistice. In the latter case, the war is carried on without any abatement. Section 9. Assassination. 148. The law of war does not allow proclaiming either an individual belonging to the hostile army or a citizen or a subject of the hostile government an outlaw, who may be slain without trial by any captor, any more than the modern law of peace allows such international outlawry. On the contrary, it abhors such outrage. The sternest retaliation should follow the murder committed in consequence of such proclamation, made by whatever authority. Civilized nations look with horror upon offers of rewards for the assassination of enemies as relapses into barbarianism. Section 10. Insurrection, Civil War, Rebellion. 149. Insurrection is the rising of people in arms against their government, or portion of it, or against one or more of its laws, or against an officer or officers of the government. It may be confined to mere armed resistance, or it may have greater ends in view. 150. Civil war is war between two or more portions of a country or state, each contending for the mastery of the whole, and each claiming to be the legitimate government. The term is also sometimes applied to war of rebellion, when the rebellious provinces or portions of the state are contiguous to those containing the seat of the government. 151. The term rebellion is applied to an insurrection of large extent, and is usually a war between the legitimate government of a country and portions of provinces of same, who seek to throw off their allegiance to it and set up a government of their own. 152. When humanity induces the adoption of the rules of regular war towards rebels, whether the adoption is partial or entire, it does in no way whatsoever imply a partial or complete acknowledgment of their government, if they have set up one, or of them, as an independent or sovereign power. Neutrals have no right to make the adoption of the rules of war by the assailed government towards rebels the ground of their own acknowledgment of the revolted people as an independent power. 153. Treating captured rebels as prisoners of war, exchanging them, concluding of cartels, capitulations, or other warlike agreements with them, addressing officers of a rebel army by the rank they may have in the same, accepting flags of truce, or on the other hand proclaiming martial law in their territory, or levying war taxes or forced loans, or doing any other act sanctioned or demanded by the law of usages of public war between sovereign belligerents, neither proves nor establishes an acknowledgment of the rebellious people, or of the government which they may have erected, as a public or sovereign power. Nor does the adoption of the rules of war towards rebels imply an engagement with them extending beyond the limits of these rules. It is victory in the field that ends the strife, and settles the future relations between the contending parties. 154. Treating in the field a rebellious army according to the law and usages of war has never prevented the legitimate government from trying the leaders of the rebellion or chief rebels for high treason, and from treating them accordingly unless they are included in a general amnesty. 155. All enemies in regular war are divided into two general classes, that is to say, into combatants and non-combatants, or armed citizens of the hostile government. The military commander of the legitimate government, in a war of rebellion, distinguishes between the loyal citizen in the revolted portion of the country and the disloyal citizen. The disloyal citizen may further be classified into those citizens known to sympathize with the rebellion without positively aiding it, and those who, without taking up arms, give positive aid and comfort to the rebellious enemy without being bodily forced thereto. 156. Common justice and plain expediency require that the military commander protect the manifestly loyal citizens in the revolted territories against the hardships of the war, as much as the common misfortune of all war admits. The commander will throw the burden of the war, as much as lies within his power, on the disloyal citizens of the revolted portion or province, subjecting them to a stricter police than the non-combatant enemies have to suffer in regular warfare. And if he deems it appropriate, or if his government demands of him that every citizen shall, by an oath of allegiance, or by some other manifest act, declare his fidelity to the legitimate government, he may expel, transfer, imprison, or fine the revolted citizens who refuse to pledge themselves anew as citizens obedient to the law and loyal to the government. whether it is expedient to do so, or whether reliance can be placed upon such oaths, the commander or his government have the right to decide. 157. Armed or unarmed resistance by citizens of the United States against the lawful movements of their troops is levying war against the United States and is therefore treason. The Civil War in the United States of America, leading to the United States Incorporated, not only impacted the states of North America, in a twist that would see the United Kingdom of Great Britain and Ireland suffer the same burdens the money makers that funded the wars had impacted on a stock market, and the Bank of England finally couldn't cope with the change in the financial power structure and fell into the hands of the Rothschild banking merchants. In 2013, Queen Elizabeth II, in her 60th Diamond Jubilee, took visit to the vaults of gold in the Rothschilds' maintained Bank of England, found in the City of London, a 16-square block of banks and towers of business that is sovereign to its own state, headed by the Lord Mayor of London. The Queen bowed in respect upon entry into the city. The Civil War and the financial collapse of two empires in the process lead to the Geneva Conventions 1864, where nations at war began to first start the road to worldwide peace. They had no choice, financially corrupted, brought to their knees, and after playing warfare against each other. A century later, the reverse would occur as the United States played a role in World War II. Over the 40 years post-Geneva, the United Kingdom of Great Britain and Ireland saw to troubles in the Indias, revoking charter of the East India Company as trustee government in India, with Queen Victoria claiming right of India as Empress, a first step towards peace, given the history of the shipping lanes and the Dutch Anglo Wars that had led to the glorious revolution that preceded Queen Victoria. Queen Victoria went to coronation in 1837, beginning her reign as Queen of the United Kingdom through royal style and titles 1837 to George V's style and title in 1917. We see that Queen Victoria attempted to separate from troubles before Great Britain and now stands in the middle of a century of some of the most important conventions of the modern age. Hague Conventions saw plenipotentiaries attend conferences over a number of matters relating to warfare, including that of what is known as land warfare. Land warfare consists of warfare amongst civilian populations, including the imposition of martial law and prohibitions by way of government acts and statutes at all levels of government. This can be demonstrated at Article 55 of the Hague 4 War on Land Convention 1907, installed in the Commonwealth of Australia on the 26th of January 1910, currently Australia Day, signed by King Edward VII as plenipotentiary of the realm, being the United Kingdom of Great Britain and Ireland, as can be demonstrated by the list of signatories heading the Convention's documents. Rules of usufruct allow for use of the fruits, and the fruits of one's labour, or the fruits of one's loins, are then put into the system that is the usufruct. That very system then catalogues and puts value to what is contained within the realm that has been occupied. The occupied as a people are still free to do their day-to-day activities, unless they challenge the position of this administration that allowed this usufruct or the use of fruits to occur in the first place. Challenging the position of this administration is seen to be belligerence and can open a whole plethora of defence tactics, including military interventions and the use of severely militarised police using ancient battle techniques. You see this in your daily lives, paying rates on your own paid-off parcels of land. You pay registrations yearly like a right has been turned into a privilege. You are fined, and the consequences always related to churning the financial wheel that keeps the system of credit running. Use of the fruits lines you up with credit. You churn to pay off. With your children handed into the game to continue the credit cycle, they become a surety too. You can see this directly by the way of the privatisation of the government-owned resources and infrastructure that provides services to the people. Department of Foreign Affairs and Trade, Canberra. International Convention concerning the laws and customs of war on land, Hague 4. The Hague, 18 October 1907. Entry into force for Australia and generally 26 January 1910. Australian Treaty Series 1910, number 8. Copyright Commonwealth of Australia 1999. International Convention concerning the laws and customs of war on land. His Majesty the King of United Kingdom of Great Britain and Ireland, and of the British Dominions beyond the seas, Emperor of India, His Majesty the German Emperor, King of Prussia, the President of the United States of America, the President of the Argentine Republic, His Majesty the Emperor of Austria, King of Bohemia, etc., and Apostolic King of Hungary, His Majesty the King of the Belgians, the President of the Republic of Bolivia, the President of the Republic of the United States of Brazil, His Royal Highness the Prince of Bulgaria, the President of the Republic of Chile, the President of the Republic of Colombia, the Provisional Governor of the Republic of Cuba, His Majesty the King of Denmark, the President of the Dominican Republic, the President of the Republic of Ecuador, the President of the French Republic, His Majesty the King of the Hellenes, the President of the Republic of Guatemala, the President of the Republic of Haiti, His Majesty the King of Italy, His Majesty the Emperor of Japan, His Royal Highness the Grand Duke of Luxembourg, Duke of Nassau, the President of the United States of Mexico, His Royal Highness the Prince of Montenegro, His Majesty the King of Norway, the President of the Republic of Panama, the President of the Republic of Paraguay, Her Majesty the Queen of the Netherlands, the President of the Republic of Peru, His Imperial Majesty the Shah of Persia, His Majesty the King of Portugal and of the Algarves, etc., His Majesty the King of Romania, His Majesty the Emperor of all the Russias, the President of the Republic of Salvador, His Majesty the King of Serbia, His Majesty the King of Siam, His Majesty the King of Sweden, the Swiss Federal Council, His Majesty the Emperor of the Ottomans, the President of the Oriental Republic of Uruguay, the President of the United States of Venezuela. Considering that, while seeking means to preserve peace and prevent armed conflicts between nations, it is likewise necessary to bear in mind the case where an appeal to arms may be brought about by events beyond their responsibility to control. Being animated also by the desire to serve, even in the extreme cases, the interests of humanity and the ever progressive need of civilization, and thinking it is important, with this object, to revise the general laws and customs of war, with the view, on the one hand, of defining them with greater precision, and on the other hand, of confining them within the limits intended to mitigate their severity as far as possible. Having deemed it necessary to complete and render more precise in certain particulars the work of the First Peace Conference, which, following on the Brussels Conference of 1874, and inspired by the ideas dictated by a wise and generous forethought, adopted provisions intended to define and regulate the usages of war on land. According to the views of the high contracting parties, these provisions, the drafting of which has been inspired by the desire to diminish the evils of war, so far as military requirements permit, are intended to serve as a general rule of conduct for the belligerents, in their mutual relations and in their relations with the inhabitants. It has not, however, been found possible, at present, to concert stipulations covering all the circumstances which arise in practice. On the other hand, the high contracting parties clearly do not intend that unforeseen cases should, in default of written agreement, be left to the arbitrary opinions of military commanders. Until a more complete code of the laws of war can be drawn up, the high contracting parties deem it expedient to declare that, in cases not covered by the rules adopted by them, The inhabitants and the belligerents remain under the protection and governance of the principles of the law of nations, derived from the usages established among civilized peoples, from the laws of humanity, and from the dictates of the public conscience. They declare that it is in this sense especially that Articles 1 and 2 of the regulations adopted must be understood. The high contracting parties wishing to conclude a fresh convention to this effect have appointed as their plenipotentiaries, that is to say, name of plenipotentiaries not listed here, who are, after having deposited their full powers found to be in good and due form, have agreed upon the following. Article 1. The contracting powers shall issue instructions to their armed land forces, which shall be in conformity with the regulations respecting the laws and customs of war on land, annexed to the present convention. Article 2. The provisions contained in the regulations referred to in Article 1, as well as in the present convention, do not apply except between contracting powers, and then only if all the belligerents are parties to the convention. Article 3. A belligerent party which violates the provisions of the said regulations shall, if the case demands, be liable to pay compensation. It shall be responsible for all acts committed by persons forming part of its armed forces. Article 4. The present convention, duly ratified, shall replace, as between the contracting powers, the convention of 29 July 1899, respecting the laws and customs of war on land. (1). The Convention of 1899 remains in force between the powers which signed it, but which do not ratify the present Convention. Article 5. The present Convention shall be ratified as soon as possible. (2). The ratifications shall be deposited at The Hague. The first deposit of ratifications shall be recorded in a protocol signed by the representatives of the powers which take part therein, and by the Netherlands Minister for Foreign Affairs. The subsequent deposits of ratifications shall be made by means of a written notification addressed to the Netherlands Government and accompanied by the instrument of ratification. A duly certified copy of the protocol relating to the first deposit of ratifications of the notification mentioned in the preceding paragraph and of the instruments of ratification shall be immediately sent to the Netherlands Government through the diplomatic channel, to the powers invited to the Second Peace Conference, as well as to other powers which have acceded to the Convention. The said government shall, in the cases contemplated in the preceding paragraph, inform them at the same time of the date on which it received the notification. Article 6. Non-signatory powers may accede to the present Convention. A power which desires to accede notifies its intentions in writing to the Netherlands Government, forwarding it the Act of Accession, which shall be deposited in the archives of the said Government. The said Government shall immediately forward to all the other parties a duly certified copy of the notification, as well as of the Act of Accession mentioning the date on which it received the notification. Article 7. The present Convention shall take effect in the case of the powers which were parties to the first deposit of ratifications 60 days after the date of the protocol recording such deposit (3), and in the case of the powers which shall ratify subsequently, or which shall accede 60 days after the notification of their ratification or of their accession has been received by the Netherlands Government. Article 8. In the event of one of the contracting powers wishing to denounce the present Convention, the denunciation shall be notified in writing to the Netherlands Government, which shall immediately communicate a duly certified copy of the notification to all other powers, informing them of the date on which it was received. The denunciation shall only operate in respect to the denouncing power, and only on the expiry of 1 year after the notification has reached the Netherlands Government. Article 9. A register kept by the Netherlands Ministry for Foreign Affairs shall record the date of the deposit of ratifications effected in virtue of Article 5, paragraphs 3 and 4, as well as the date on which the notification of accession (Article 6, paragraph 2), or of denunciation Article 8, Paragraph 1, close bracket, have been received. Each contracting power is entitled to have access to this register and to be supplied with duly certified extracts from it, in faith whereof the plenipotentiaries have appended their signatures to the present convention, done at The Hague on 18th October 1907 in a single original, which shall remain deposited in the archives of the Netherlands Government, and of which duly certified copies shall be sent, through the diplomatic channel, to the powers invited to the Second Peace Conference. Bracket signatures not reproduced here, close bracket. Annex. Regulations respecting the laws and customs of war on land. Section 1 of Belligerents. Chapter 1. The status of belligerent. Article 1. The laws, rights and duties of war apply not only to the army, but also to militia and volunteer corps, fulfilling all the following conditions. 1. They must be commanded by a person responsible for his subordinates. 2. They must have a fixed distinctive sign recognizable at a distance. 3. They must carry arms openly, and 4. They must conduct their operations in accordance with the laws and customs of war. In countries where militia or volunteer corps constitute the army or part of it, they are included under the denomination army. Article 2. The inhabitants of a territory not under occupation who, on the approach of the enemy, spontaneously take up arms to resist the invading troops without having had time to organize themselves in accordance with Article 1, shall be regarded as belligerents if they carry arms openly and if they respect the laws and customs of war. Article 3. The armed forces of the belligerents may consist of combatants and non-combatants. In the case of capture by the enemy, they both have the right to be treated as prisoners of war. Chapter 2. Prisoners of war. Article 4. Prisoners of war are in the power of the hostile government, but not of the individuals or corps who captured them. They must be humanely treated. All their personal belongings except arms, horses, and military papers remain their property. Article 5. Prisoners of war may be interned in a town, fortress, camp, or other place, and are bound not to go beyond certain fixed limits, but they cannot be placed in confinement except as an indispensable measure of safety, and only while the circumstances which necessitate the measure continue to exist. Article 6. The state may employ the labour of prisoners of war other than officers according to their rank and capacity. The work shall not be excessive and shall have no connection with the operations of the war. Prisoners may be authorised to work for the public service for private persons or on their own account. Work done for the state is paid for at rates proportional to the work of a similar kind executed by soldiers of the National Army, or, if there are no such rates in force, at rates proportional to the work executed. When the work is for other branches of the public service or for private persons, the conditions are settled in agreement with the military authorities. The wages of the prisoners shall go towards improving their position, and the balance shall be paid to them on their release, deductions on account of the cost of maintenance accepted. Article 7. The government into whose hands prisoners of war have fallen is charged with their maintenance. In default of special agreement between the belligerents, prisoners of war shall be treated as regards rations, quarters, and clothing on the same footing as the troops of the government which captured them. Article 8. Prisoners of war shall be subject to the laws, regulations, and orders in force in the army of the state in the power of which they are. Any act of insubordination justifies the adoption towards them of such measures of severity as may be considered necessary. Escaped prisoners who are retaken before being able to rejoin their own army or before leaving the territory occupied by the army which captured them are liable to disciplinary punishment. Prisoners who, after succeeding in escaping, are again taken prisoner are not liable to any punish on account of their previous escape. Article 9. Every prisoner of war is bound to give, if questioned on the subject, his true name and rank, and if he infringes this rule he is liable to have the advantages given to prisoners of his class curtailed. Article 10. Prisoners of war may be set at liberty on parole if the laws of their country allow it, and in such cases they are bound, on their personal honour, scrupulously to fulfil, both towards their own government and the government by which they were made prisoners, the engagements they may have contracted. In such cases their own government is bound neither to require of nor accept from them any service incompatible with the parole given. Article 11. A prisoner of war cannot be compelled to accept his liberty on parole. Similarly, the hostile government is not obliged to accede to the request of a prisoner to be set at liberty on parole. Article 12. Prisoners of war liberated on parole and recaptured bearing arms against the government to which they had pledged their honour, or against the allies of that government, forfeit their right to be treated as prisoners of war, and may be put on trial before the courts. Article 13. Individuals following an army without directly belonging to it, such as newspaper correspondents or reporters, sutlers or contractors, who fall into the enemy's hands, and whom the latter thinks is expedient to detain, are entitled to be treated as prisoners of war, provided they are in possession of a certificate from the military authorities of the army which they were accompanying. Article 14. A Bureau for information relative to the prisoners of war is instituted at the commencement of hostilities in each of the belligerent states, and when necessary in neutral countries which have received belligerents on their territory. The business of this Bureau is to reply to all inquiries about the prisoners, to receive from the various services concerned full information respecting internments and transfers, releases on parole, exchanges, escapes, admissions into hospital, deaths, as well as all other information necessary to enable it to make out and keep up the date and individual return of each prisoner of war. The Bureau must state in this return the regimental number, name, surname, age, place of origin, rank, unit, wounds, date, and place of capture, internment, wounding, and death, as well as any observations of a special character. The individual return shall be sent to the government of the other belligerent after the conclusion of peace. It is also the business of the Information Bureau to gather and keep together all personal effects, valuables, letters, etc., found on the field of battle, or left by prisoners who have been released on parole, or exchanged, or who have escaped, or who died in hospitals or ambulances, and to forward them to those concerned. Article 15. Societies for the relief of prisoners of war is properly constituted in accordance with the laws of their country, and with the object of serving as the channel for charitable effort, shall receive from the belligerents, for themselves and their duly accredited agents, every facility for the efficient performance of their humane task within the bounds imposed by military exigencies and administrative regulations. Representatives of these societies, when furnished with the personnel permit by their military authorities, may, on giving an undertaking in writing to comply with all measure of order and police which they may have to issue, be admitted to the places of internment for the purpose of distributing relief, as also to the halting places of repatriated prisoners.